Today we have yes. We have also discussed about the Article 19 1A of the Indian Constitution and the limitations which are laid down on Article 19 1A, that is right to freedom of speech and expression, and the reasonable restrictions which are laid down on the freedom of speech and expression that got laid down under Article 19(2) of the Indian Constitution that we have discussed as part of the syllabus, and we have discussed about the 8 salient features of Indian Constitution. Okay. Today we'll discuss about the Right to Information Act, and depending on the time, we'll also discuss about the other media law, whatever the concepts you have, the media laws. So Right to Information Act, in the previous class yesterday, we have discussed that right to information is also a fundamental right. So here, as a citizen in this country, maybe we want to know what is happening throughout the globe. So here, we also have a right to know about the functioning of the government, about the administrative of departments, maybe how much amount is being spent by the government, maybe in constructing the bridges, or maybe uh, uh, laying down the roads or whatever. So whatever maybe, generally, if you want to know what is happening, generally we most of the time depending on the media. And here, as a citizen in this country, to promote a transparency among the working of the government, etc., if you want to know certain kind of information, you can ask under the Right to Information Act. So the Right to Information Act was enacted in 2005. It provides a citizen the right to access to the information that is under the control of the government authorities. So here, it is a fundamental right of every citizen in this country to access to the information which is under the control of public authorities. So if you would like to know what is happening in the government, or how much amount is spent on constructing bridges, or maybe how much amount is spent for implementing the social elevation schemes, etc., whatever, if you want, if it is not classified information, generally, if it is not exempted to provide under the Right to Information Act, that will not be disclosed by the concerned organizations. But the rest of the information you can ask from the government authorities, and it is the duty of the public information officers to provide that information to the RTI applicants. So it is a fundamental right of every citizen in this country to access to the information that is under the control of the government authorities. So the right to information is made as a fundamental right under Article 19 of the Indian Constitution and Article 21 of the Indian Constitution. So Article 21 speaks about the right to life. Every citizen in this country have the right to life and personal liberty, except according to the procedure that is established by law, which means the right to life is a fundamental right of every citizen in this country protected under Article 21. And right to information, right to education, that is enacted, that came into force from April 1st, 2010, even that is also incorporated under Article 21A of the Indian Constitution. And later on, if you see, the right to privacy is also a fundamental right. The Supreme Court of India, in a judgment, upheld that the right to privacy should be protected under Article 21 of the Constitution, and it is a fundamental right of each and every citizen in this country. The judgment was announced on August 24th, 2005. 17. So even the Supreme Court of India recognizes the right to privacy as a fundamental right, and RTI is also a fundamental right that is protected under Article 19 and 21 of the Indian Constitution. So here, if you see the Right to Information Act, when the Right to Information Act was enacted, the earlier, whatever the Freedom of Information Act, whatever was the Freedom of Information Act of 2002, that was repealed. So here, certain kind of information earlier, if you see, it was access to the information that is restricted under the provisions of the Official Secrets Act of 1923. And if you see the Official Secrets Act of 1923, the information, the government information used to be classified into two categories. One is classified information and the other one is non-classified information. And access to the classified information was restricted by the law under the provisions of the Official Secrets Act of 1923, and the rest of the information, non-classified information, that can be disclosed to the public. And why the classified information was restricted to access to the information is because that might endanger the national integrity or security of the state or anything, whatever the reasonable restrictions which are laid down under Article 19.2 also fall under this classified information. So here, later on, when the RTI Act came into existence, the access to the information, whatever was restricted under the Official Secrets Act, is also now able to disclose for the individuals. But there is a section under under the Right to Information Act, that is Section 8 of the RTI Act, that is something which makes certain exemptions in providing information to the RTI applicants. So here, the Cabinet of, if you see this Right to Information Act, it is an act that is providing an access to the information as a right to information as a fundamental right of the citizens in this country. So this RTI Act was enacted on June 15, 2005, but it came into force only on October 12, 2005. The RTI Act enacted to provide for setting out the practical regime of right to information for the citizens in this country to access to the information that is under the control of the public authorities in order to promote accountability and transparency in the working of each public authority. And the RTI, just now I said, replaces the earlier Freedom of Information Act of 2002. And under the provisions of this RTI Act, an individual can request for information to the public authority, and from the date of receipt of application, it is the duty of the concerned public information officer of the organization to provide information to the RTI applicant. So the RTI process starts from making an application with the PIO of an organization, and it ends with the timely disclosure of information to the RTI applicant. And the time limit that is specified under the Right to Information Act is 30 days from the receipt of filing of an RTI query or application by an individual. So if you see RTI Act, organizations or institutions that are under the purview of the Right to Information Act. So all those constitutional institutions, authorities, that including the executive, judiciary, legislature, and any other institution or organization or a body that is established or constituted by the Act of Parliament or a state legislature. So any organization that is constituted by the Act of Parliament or a state legislature that is under the purview of the Right to Information Act. And it also covers that directly or indirectly, any organization that is owned, controlled, or substantially funded by the government. And private institutions or private organizations that will not come under the Right to Information, under the purview of the Right to Information Act, but the private institutions and the NGOs that receives 95% of their infrastructure funds from the government, then those NGOs or private institutions also will fall under the Right to Information Act. And this Right to Information Act is governed by two bodies. One is the Central Information Commission and the other one is State Public Information Commission. And the State Information Commission in a order made clear that all those political parties, the 7 national political parties that includes Congress, BJP, NCP, CPI Marxist, CPI, BSP, and BJD have substantially funded indirectly by the central government and have the character of public authorities and other provisions of the Right to Information Act as they perform public functions. So the Central Information Commission made an order saying that these 7 political parties also should fall under the Right to Information Act because they are discharging first public functions and also they receive substantially funding from the government. But in August 2013, the government introduced a Right to Information bill, amendment bill, that would remove the political parties from the scope of the Right to Information Act. So the bill is still not is pending, but at present, no political party is under the purview of the Right to Information Act. And in the year 2019, the RTA Act was amended and that was passed on July 25th, 2019, that modified the terms and conditions of service of the members of the Central Information Commission and the information commissioners at the central and also at the state level. And this has been criticized, the watering down the independence of the information commissions. But even though the act was, the bill was passed. So if you see the objectives of Right to Information Act, the major objective of your Right to Information Act is to empower the citizens in this country to access to the information that is held by the public authorities to promote transparency and accountability in the working of the government-run institutions. And as we know, an informed citizen is better equipped to keep necessary vigil on the instruments of governments and make the government more accountable to the public. And the RTA Act is a step towards making the citizens informed about the activities of the government to promote transparency and accountability among the working of the government institutions. So under the major objective is of the Right to Information Act is to promote transparency and accountability in the working of the government-run institutions. And if you see the 2 major bodies that are functioning that based on the provisions of the Right to Information Act, one is the Central Information Commission and the other one is the State Information Commission. So the Central Information Commission is set up under the provisions of the Right to Information Act of 2005, and it is a body that will be taking up the complaints which received by the public. And CIC, the Central Information Commission, that consists of a Central Chief Information Commissioner, and there are not more than 10 information commissioners who would be assisting the Central Chief Information Commissioner in the work. And CIC and the Central Information Commissioner and the information commissioners of the Central Information Commission are to be appointed by the President of India. And when it comes to your State Information Commission, it is constituted by the state government by issuing a gazette notification, and it consists of one state chief information commissioner and not more than 10 state information commissioners, and they are to be appointed by the governor of the concerned state. If you see the Central Information Commission, that Central Information Commission was constituted and that came into force from October 12, 2005 under the provisions of the Right to Information Act of 2005. So the Central Information Commission is headed by the Central Chief Information Commissioner. And the Central Information Commissioner and the Central Information Commissioners are to be appointed by the President of India on the recommendation of a committee that would consist of the Prime Minister, who acts as the chairperson of the committee, and the leader of opposition in Lok Sabha, and a Union Cabinet Minister to be nominated by the Prime Minister of India. So which means the Prime Minister who acts as the chairperson, and along with that, he nominates a Union Cabinet Minister for the committee to be a member of the committee, and the leader of opposition in Lok Sabha, they recommend the names for the positions of Central Chief Information Commissioner and the Central Information Commissioners of the Central Information Commission, and they are to be appointed by the President of India. And the Chief Information Commissioner will be assisted by the Information Commissioners, who are not more than 10 Information Commissioners who are to be appointed by the President of India in direction and management of the affairs of the Central Information Commission based on the objectives of the Right to Information Act. And the Chief Information Commissioner and Information Commissioners are to be persons of eminence in public life with wide knowledge and experience in field of law, science and technology, social service, management, journalism, mass media, or administration and governance. The Chief Information Commissioner or an Information Commissioners shall not be a member of Parliament or member of state legislature of any state or any union territory. As the case may be, they hold office and they're not holding any office of profit or connected with any political party or carrying out any business or pursuing any profession. So those who are going to be appointed for the positions of Chief Information Commissioner and Information Commissioners will not hold any other work or will not be working in any of the institutions or members of Parliament or state legislatures, etc., or they are not doing any other works. So they are to be appointed for the positions of the Central Chief Information Commissioner and the Central Information Commissioners of the Central Information Commission. If you see the term of the Central Information Commission, three members, that includes the Chief Information Commissioner of the Central Information Commission. He or she holds office for a term of 5 years from the date upon he takes over the charge as the Chief Information Commissioner, or till he attains the age of 65 years, whichever is earlier. And the Chief Information Commissioner of the Central Information Commission is not eligible for the reappointment as the Chief Information Commissioner. And when it comes to the Chief Information Commissioner or Information Commissioners, at any point of time, by writing under his hand addressed to the President of India, may resign from their office. And the President also have a right to suspend the Chief Information Commissioners or the Information Commissioner of the Central Information Commission, and this President also may prohibit them from attending the office during any of the inquiry against the members. And the Chief Information Commissioner or any Information Commissioner shall be removed from his office by the order of the President. When you see the State Information Commission, every state, by issuing a Gazette notification, shall constitute their own State Information Commissioner, the State Information Commissions, based on the provisions of the Right to Information Act of 2005. And the same way, the State Information Commission also consists of a State Chief Information Commissioners and not more than 10 State Information Commissioners. And the State Chief Information Commissioner and also the State Information Commissioners are to be appointed by the Governor of the concerned state on the recommendation of a committee that consists of the Chief Minister, who acts as the chairperson of the committee and the leader of opposition in state legislative assembly, and a union, and a cabinet minister who is to be nominated by the Chief Minister. So the committee would recommend the names for the positions of State Information Commission and State Chief Information Commissioner and the State Information Commissioners. And here, based on the provisions of the Right to Information Act of 2005, the direction, management of other affairs of the State Information Commission is vested with the State Chief Information Commissioner, and who will be assisted by the State Information Commissioners in discharging the functions of the State Information Commission under the provisions of the Right to Information Act. And the State Chief Information Commissioner and the State Information Commissioners also will hold office for a term of 5 years or till they attain the age of 65 years. And the State Information the State Information Commissioners also shall hold office for a term of 5 years from the date of taking over the charge as the Information Commissioner of the State Information Commission and till they attain the age of 65 years, whichever is earlier, and shall not be eligible for reappointment as State Information Commissioner, provided that the State Information Commissioner shall, on vacating his office, will be eligible for appointment as the State Chief Information Commissioner, but in aggregate, the person should only hold office for a term of 5 years as a State Information Commissioner and the State Chief Information Commissioner of the State Information Commission. And the same way, the State Chief Information Commissioner or the State Information Commissioner may resign from his office by addressing a letter to the governor of the concerned state. The same way, the State Chief Information Commissioner or a State Information Commissioner shall be removed from his office only by the order of the governor of the concerned state. And the governor also have a right to suspend the State Chief Information Commissioner or State Information Commissioner from his office if it is necessary. And also the governor may also prohibit the State Chief Information Commissioner or Information Commissioners from attending the office during an inquiry against them. If you see the process of Right to Information Act, the process of RTI involves timely disclosure of information by the public authorities. It starts with receiving a RTI request from a citizen of this country and ends with providing information to the applicant by the public information officer of the concerned state or a central government. So in each authority or an organization which is under the purview of the Right to Information Act should appoint their own public information officers, and any person may write a request to the public information officer for information. And an individual may submit a written request seeking information to the PIO, and it is the duty of the concerned PIO to provide information to the RTI applicant. And when the RTI request that is related to another public information, it relates to any other public authority or any other organization completely or partially, then it is the duty of the concerned public information officer to transfer or forward the information request to the concerned PIO of the other authority within 5 working days. So in addition to the 30 days, generally, it will addition to the authority, So here, the PIO, while sending or forwarding that information request to any other authority, then it is the duty of the PIO to inform the RTI applicant also the same. So while filing the RTI request, the applicant has to disclose his name, contact details, etc. And there is not necessary for an applicant to provide details or defense for seeking information under the Right to Information Act. But later on, the Whistleblowers Protection Act also came to existence, where there is no need for providing your details or contact name or contact details to seek information from the concerned PIOs under the under the provisions of the Right to Information Act. So the Central Information Commission receives the complaints from the individuals where the individuals are not able to submit their request to the Central Information Commissioner, Central Public Information Officer, or State Public Information Officer, as the respective PIO not having been appointed, or because the Central Assistant PIO or State Assistant PIO refuses to receive RTI application from the concerned individual. So if you want to make an RTI application, then you have to pay 10 rupees demand draft or postal draft or a banker's check to be payable to the accounts officer of the concerned public authority, and you can make an application for seeking information under the provisions of the Right to Information Act. And if it is necessary, further fees has to be paid by the RTI applicant. The same has to be communicated by the PIO of the organization to the RTI applicant, and the RTI applicant has to pay the additional fees, whatever, for getting the information from the organization or the PIO. The time bound period, which is specified under the RTI Act, for the disclosure of information to the RTI applicant. So if a request has been made to the PIO, the Public Information Officer, then the reply is to be given within 30 days from the date of receipt of application by the PIO. And if the request is made to the Assistant Public Information Officer, the reply is to be given within 35 days from the date of receipt of an application from the citizens. Then if the PIO, the Public Information Officer, transfers the information request to any other public authority, the time allowed to reply is 30 days, but it is calculated from the day after it is being received by the other PIO or the transferee authority. Then if the information regarding corruption and human rights violations are involved, or the security and scheduled is etc., it has to be provided within 45 days, but with the proper approval of the Central Information Commission. And in the life and liberty of a person is involved, then it is the duty of the Public Information Officer to provide information to the RTA applicant within 48 hours from the day of receiving the RTA request. And if a person does not receive any information under the Right to Information Act from the concerned Public Information Officer, then the applicant may appeal to the next ranked senior officer after the expiry of the 90 days or 3 months period. Then the applicant may make a request to he may approach the State Information Commission or the Central Information Commission, and he can make a complaint. Then it is the duty of the Central Information Commission or the State Information Commission to look after the case and to ensure that the information is provided to the RTA applicant. And here, the Central Information Officer or the Central Information Officer and the State Public Information Officer will hear arguments from both the parties and finalize the case, or ask the concerned Public Information Officer to provide information to the RTA applicant within a stipulated period of time. And also the Central Information Commission or State Information Commission may also impose a penalty on the Public Information Officers. And under the Section 8 of the Right to Information Act, certain information, the disclosure of certain information is restricted, and the disclosure of information that would prejudice, that would affect. So the disclosure of any information which would affect the sovereignty, integrity, and unity of the country, security of the state, and which affects the scientific, strategic, or economic interests of the state, which means the nation, and anything if it affects the relations with the foreign state or anything which leads to incitement to an offense, and the disclosure of any information which has been specifically prohibited to be published by any tribunal or court of law, or the disclosure of any information which may constitute contempt of court. The disclosure of any information which would cause a breach of privilege of the state legislature or assembly or a parliament, then that kind of information also will not be disclosed to the RTI applicant. The information that includes the trade secrets, commercial confidence information, including the trade secrets, commercial confidence, intellectual property, and the disclosure of information that would harm the competitive position of any third party, unless the competent authority is satisfied that the larger public interest permits the disclosure of such information. Information which is available to a person in his or her fiduciary relationship, unless the competent authority is satisfied that the larger public interest warrants the disclosure of such information. Information that is received in confidence from a foreign state, that also will not be disclosed to the RTA applicant. The disclosure of any information that would threaten the life or physical safety of an individual, identify the source of information or assistance given in confidence for law enforcement or security purposes, then that kind of information also cannot be disclosed to the RTI applicant. And information which would hinder the process of any investigation or causes apprehension or prosecution of offenders, then that information cannot be disclosed to the RTI applicant. And information relating to cabinet papers, including records of deliberations of the Council of Ministers, secretaries, and other officers, etc., cannot be disclosed. And disclosure of any information which relates to personal information, the disclosure of which has no relationship to any public activity or interest, then if it would cause unnecessary invasion of the privacy of an individual, then it cannot be disclosed. However, the public authority may provide personal information of any person in the larger public interest. The central intelligence security agencies are excluded from providing information to the RTA applicants. However, these organizations have a responsibility to provide information relates to allegations of human rights violations and corruption, but only with the proper approval of the Central or State Information Commission. If you see the penalty, the Central Information Commission or State Information Commission, while deciding on complaints, finds that without any reasonable cause, a public authority refuses to receive an RTI application from the individuals, or has not furnished information within the time specified under the RTI Act, or deny the request for information, or knowingly gives incorrect, misleading, or incomplete information to the RTI applicant, or destroys information which was subject of the request, or obstructed in any manner in furnishing the information, a penalty of 250 rupees is imposed per day till the RTA applicant receives the information from the required PIO, or till the information is furnished. However, the total amount of such penalty shall not exceed rupees 25,000. And in a case, if you see the one example of how the RTI request might not be taken into account and information might not be provided, even though the larger public interest is involved. the Delhi Chief Minister Arvind Kejriwal, he filed an application to the Gujarat University to provide the degree of the Prime Minister of India, seeking his BA degree certificate. But the Gujarat University stating that it is a personal information of the Modi ji, stating that as it is a personal information, they stated they could not provide information to the Kejriwal. And even the Kejriwal approached the Central Information Commission, made a complaint with the Central Information Commission, and the Central Information Commission ordered to provide information to Mr. Kejriwal as the larger public interest is involved in the case. But later, the Gujarat University approached the Gujarat High Court saying that to quash the order of the Central Information Commission that said that information has to be disclosed to the Mr. Kejriwal relates to the certificate of Mr. Modi ji. But even though the Gujarat High Court quashed the order of the Central Information Commission stating that it might affect the privacy of Mr. Modi ji, and stating that it is a personal information and there is no need to provide that information to the RTA applicant, Mr. Kejriwal. So here, blatantly, sometimes the information which has to be provided in the larger public interest is also might not be provided. It is a simple case where even the information might be available in public domains. It is the duty of us to know the authentic information from the Gujarat University, and the larger public interest is involved here. But the RTA Act in its objective states that when the larger public interest is involved, even though it is a personal information, that if it is not harming the individuals in any way, that information in the larger public interest should be provided to the RTA applicant. But in this case, even though the Central Information Commission ordered the Gujarat University to provide information, the order was quashed by the Gujarat High Court, stating the right to privacy as the major reason. Right to Information Act of 2005, the right to you see that replaces the earlier Freedom of Information Act. It was enacted on October 12th. Sorry, it was enacted on June 15, 2005, but it came into force only on October 12, 2005. Under the provisions of the Right to Information Act, anyone can request to the information from the public information officers or organization that is under the control of the governments, and it is the duty of the public information officer of the organization to provide information to the RTA applicant. And we have two bodies at central and state level, the Central Information Commission and the State Information Commission. Both the organizations, both these institutions have been constituted based on the provisions of the Right to Information Act to take up the complaints from the individuals where the PIOs would not provide or provides misleading information or blatantly denies information to the RTA applicants. Okay, we'll stop here. I think we have some 15 minutes time. Tomorrow, anyway, we will have a class note tomorrow. Again, we'll meet on next Friday. We'll discuss some more acts as part of your syllabus. Okay, I'm stop sharing the content. I will also leave the session. Thank you.